jokes in this book are hysterical, by the way. I
Thank
love
you,
that. The
thank
Harold
you,
Ramis
thank
stuff
you,
is
thank
very.
you. Hi. How are you?
Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution. As those of you who've been here before know, the National Constitution Center is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And as part of this inspiring charter, we have a mission that we call our aspiration to be America's town hall, the one place in America where citizens can come and hear the best arguments on all sides of constitutional issues in the news and make up their own minds. My favorite town hall debate of the past month or longer was one that Alan Dershowitz participated in about 2 weeks ago. This was a debate that we co-hosted with the great group Intelligence Squared about whether the president has the constitutional power to target and kill American citizens abroad. And the audience voted before the show, and they narrowly voted no, he didn't have that power. And after Alan Dershowitz gave what I have to say was the most inspiring closing arguments I have ever heard, the audience changed its mind and voted that the president did have the power to target and kill American citizens abroad. And that was just one example of, first of all, Professor Dershowitz's willingness to argue against his political instincts or against type, and also his extraordinary persuasiveness as a constitutional advocate. I won't bury the lead, ladies and gentlemen. Alan Dershowitz is one of my constitutional heroes. When I was a high school kid in New York City long, long ago, in the mists of the 1980s, I had on right by my bed his great book, The Best Defense, and read it again and again. I don't know that it convinced me to be a lawyer, but I wanted to be a civil libertarian who would defend the rights of people I disagreed with. And now he's just written this really riveting book. I stayed up all night and read it from cover to cover. I couldn't put it down, and it's a summary of an extraordinary career in the law. The blurb is great. It notes that he's been called the winningest appellate criminal defense lawyer in history, and that his legal practice has been characterized as the most fascinating on the planet. But even better, ladies and gentlemen, are the blurbs for this great book. I don't read Dershowitz, President Jimmy Carter. Dershowitz is not very bright, and he's strongly opposed to civil liberties, Noam Chomsky. Dershowitz is evil, like Adolf Eichmann, offering Nazi moral judgments, Norman Finkelstein, and finally, you're not as nasty a guy as my right-wing friends believe, Justice Antonin Scalia. So speaking of Justice Scalia, Professor Dershowitz, yesterday I think was your 50th anniversary as a law clerk. You were at the Supreme Court with 7 of the justices or so. Tell us what that was like.
It was, first of all, thank you for inviting me to this wonderful place. You know, until I came here, I had no idea how magnificent this building is. We shook hands with all the framers of the Constitution, people whose work I've been reading for years, people whose books I own. And it was, to me, just a fantastic emotional experience that my wife and I both shared and enjoyed. My wife's from Charleston, South Carolina, so she made sure to say hello to the Pinckneys and the Eldridges and the folks from South Carolina. I said hello to Madison and a few others. It's fantastic, and you couldn't have a better leader than Jeff. He's fantastic, extraordinarily well-respected among constitutional scholars, and has this rare ability to speak both to academics and to the general public. Certainly a talent I greatly admire. So 50 years ago, this kid from Brooklyn with a thick accent walks into the United States Supreme Court to serve as a law clerk. I was scared out of my wits. And this is 1963. The cases on the docket included the civil rights laws, reapportionment, New York Times versus Sullivan. I would say our year we had, of the 100 most important cases of the 20th century, we probably had 25 of them. Escobedo, just unbelievable. And this kid from Brooklyn is being asked, first thing that Justice Goldberg said to me is he said, "What is this?" And he threw a certiorari petition at me. I said, "It's a certiorari petition." He said, "No, this document marks the end of the death penalty in America." I said, "What are you talking about?" He said, "I came to this court determined to abolish the death penalty, and I purposely picked you as my law clerk because I knew you had a lifetime commitment against the death penalty, and together we're going to find the death penalty unconstitutional." I said, "Mr. Justice, it's in the Constitution. It says in the Fifth Amendment you can execute people. It's a living Constitution." He said, "We'll find a way." And he said that summer I had to spend all summer finding every conceivable argument I could against the death penalty. And sure enough, 5 years later, the Supreme Court declared the death penalty unconstitutional. Then it was declared constitutional. But the process began. It was such a thrill being there 50 years ago. So one of our law clerks decided, why not have a reunion? So there were 19 of us. Today there are 45 or so clerks. But in our day, each justice had 2. Justice Douglas only had 1, and the chief had 3. So we had 18, I guess. 2 or 3 have passed away, and 14 of the 15 showed up from Hawaii, from Texas, from all over. And I called Justice Breyer, who's an old friend of mine, and Justice Kagan, who was my student and then my dean. And I asked them if they would come to the lunch. And they did, and they brought with them the Chief Justice, Justice Alito, Justice Kennedy. And it was remarkable, just sitting with these justices and just schmoozing. With Justice Ginsburg, all we talked about was opera. With Justice Scalia, I serenaded him with a song. Scalia, Scalia, I just met a judge named Scalia. So,
Beautiful.
Right. And and it was just amazing. And they, treated us, we were older than they are, for the most part. And it was just an amazing experience to sit with these justices in the Supreme Court, knowing how human they are. As Justice Jackson once said, we are infallible. We are not final because we're infallible. We're infallible only because we're final. And it's, when you get to see the justices and see them in action, I had also watched 2 of the arguments, the Hobby Lobby case, very important religious freedom case, and a case involving whether the Secret Service could differentially clear out anti-Bush demonstrators but keep pro-Bush demonstrators. 2 remarkable cases. So it was a great day yesterday, and today is going to be an even greater day here. Thank you.
It will indeed. Well, I want to start with your childhood and move up, but you mentioned Hobby Lobby and you were there yesterday.
Right.
Just give us a sense, what were the best arguments on both sides, and what was your sense of how the court is going to go?
Well, I was very disappointed with the Solicitor General of the United States. I didn't think he did a good job. I thought the lawyer for the Hobby Lobby, who's, I'm much less sympathetic to Hobby Lobby's views, political views. They are opposed to many forms of contraception, and they want religious exceptions for not ensuring their female employees to use these 4 methods of contraception which they believe are abortion. But Hobby Lobby's lawyer, the former Solicitor General of the United States, Paul Clement, did a brilliant, brilliant job. And by the way, Hobby Lobby, there were 2 sets of plaintiffs in the case. Hobby Lobby and another kind of wood company both had the same argument. They said, look, you can't make us buy insurance against our religious principles to pay for medical procedures that we find religiously offensive. That was their argument. And fortunately, both sides got together and had Paul Clement make their argument, fortunately for them. So he had a full 45 minutes instead of breaking it in half. And then Varelli, the Solicitor General, argued for the United States government. So the main argument that Hobby Lobby makes is, in America, the right of conscience trumps the economic benefits or the social benefits of this kind of legislation. The government of the United States said, no, you can't create exemptions for religious exceptions. If you do, what about vaccination? What about people who won't insure for other kinds of medical procedures? What about Seventh-day Adventists or Jehovah's Witnesses or others who wouldn't insure for blood transfusions? What's the limiting principle here? And of course, the history, you have to understand the history a little bit. About 25 years ago, a peyote Native American was arrested for smoking peyote. And the Supreme Court decided, Justice Scalia, interesting, who's a very religious man, deeply religious man, decided that if you have a law of neutral application, the law is nobody can use peyote, the Constitution doesn't require an exception. I remember asking him once, you weren't alive during Prohibition, but what if the statute didn't permit Catholics to use wine for sacramental purposes? Would that be unconstitutional? And he said, no, it would not be. We wouldn't be able to use wine for sacramental purposes. Of course, Congress wrote an exception into those laws. So after the peyote case was decided, Congress, with a unanimous vote in the House, imagine a unanimous vote today at anything, and 97-3 in the Senate, voted for the Religious Restoration Act that overruled the Supreme Court's decision. Checks and balances, non-constitutional decisions can be overruled, and said that if there is a legitimate religious claim of conscience, the government has to show very strong interests that overcome that religious claim of conscience. So that's the issue. The other issue is whether a corporation, both of these companies were S corporations, that is small family-held corporations, whether corporations can have religious rights. Can a corporation be religious? Or are corporations just neutral sieves for bringing in money? And those are the two basic issues.
Okay, that's beautifully described in a balanced way. I can't resist. If you had, I don't know, 30 seconds to give the Dershowitz treatment to why corporations aren't persons, what would the argument be?
Well, I actually think in this case, this kind of corporation probably should be regarded as a person. I think I would put the issue a little differently. Obviously, if Hobby Lobby decided not to incorporate, they could challenge this law. So the fact that they sought S-corporate status, which is a major financial advantage under the law, should that change its status? In other words, should they suffer an economic penalty for their exercise of religious freedom? I think it would be a very different case if Exxon came in and said, we have religious views. Publicly held corporations are different. They're probably not allowed to have religious views because they have a fiduciary obligation to their stockholders. But this is a family-held corporation, and I think it would be elevating form over substance to deny them their constitutional rights.
And Chief Justice Roberts seemed to be moving toward a narrow compromise along those lines,
That's
suggesting that closely held corporations can bring the suits, but other corporations might be a different matter. You think you might get a majority for that?
I think for that view, he's going to get a majority. I think the court will hold that corporations of this nature have the right to bring this. But on the merits, the case, as usual, for one side, for the other, and there's Justice Kennedy sitting in the middle, and he asked two hard questions, one on each side, and nobody could tell how he was going to come out. My prediction, Hobby Lobby will narrowly win on a very narrow ground.
Great. I mean, great prediction. I'm not expressing a view on whether or not it's a great thing. On a nonpartisan basis,
And by the way,
that's
the
our
reason
charter.
they will win is because the Supreme Court knows if they lose, Congress will simply overrule them again and simply make S corporations subject to this exception. So there's always enough votes in Congress for religious freedom, which is why we have a system of checks and balances. Because if Congress had its way, we'd have prayer in the schools. We'd have, perhaps even a preamble. As you probably know, after the Civil War, they tried to write a preamble to the Constitution, which included reference to Christianity and Jesus. And Congress will almost always pass laws favoring religion, which is why the First Amendment took that issue out of the hands of the popularly elected representatives.
Which has been a great theme of your career. All right, we have to start at the beginning of this great book with your 6th grade report card.
Oh, I knew you'd
which you
raise
still
that.
have. Okay, here we go. Unsatisfactory in deportment and getting along with others. D in effort and achievement and comprehension. D in respect the rights of others. You did get an A in speaks clearly. And your mother and the teacher told your mother, his body is clean, but his mind is dirty. He refuses to show respect to his rabbis.
Has anything changed? I think early report cards are very predictive of how you're going to develop in life. Even at the end of high school, I have a photograph. I found my high school senior year report card. And in the picture section, I have a photograph of my senior semester report card. 60 in physics with a red circle around it, 60 in math with a red circle behind it, 65 in Hebrew. I went to a Jewish parochial school, and 2 other pretty lousy grades. Okay, flash forward 2 months. This is June, I barely graduate, June of 1955. September of 1955, I enter Brooklyn College. A+ in physics, A+ in math, first in my class, top of the class in everything. What happened? I could never figure it out. In 2 months, I turned from a terrible, terrible student, graduating with a 68 average from a mediocre high school, to within 5 years being first in my class at Yale Law School, which is probably one of the most selective law schools in the country. Did I have different water? I don't know. What was going on? And so I had to write a book to try to figure out what changed in my life over that short period of time.
And you said summer camp had a lot to do with it. It gave you confidence.
Summer camp gave me confidence. When I went to summer camp, people told me I was smart. And I took them seriously. And when I went off to college, I decided to pretend I was smart. Of course, for the first 3 years, I thought they were going to catch me and figure out I was really this dumb guy who was pretending to be smart. I had all these doubts. I had all the same dreams probably so many of you had, being late for exams, not being able to find my exam. But after a while, I was getting all these good grades. I figured maybe they were right, and my yeshiva teachers weren't right. My yeshiva teachers would tell me if I came up with a good idea, they'd raise my hand and come up with a good idea. They would say, if your idea is such a good one, the rabbis who are so much smarter than you would have thought of it first. If the rabbis who are so much smarter than you didn't think of it first, it can't be such a good idea. So, they persuaded me.
Okay, I want a little more singing. Do the whistle. Do the whistle while you work.
What did we sing when we were a kid? Yeah, whistle while you work. Hitler is a jerk. Mussolini is a meanie. This last part I hate to say. And the Japs are worse. But that's what we used to sing. I hear some of you know that song. And what else did we have? Oh yeah, we had so many of those little. And we got paid a penny a day in Rockaway Beach to look for German submarines. And so we took it so seriously. I was like 7 years old. We would sit there, we'd watch, and every time we saw a bird, that's a submarine, that's a submarine. We never got a submarine, never caught a submarine.
That's like a Mel Brooks movie when he's going off looking for Hitler.
Right,
yeah. But of course there were submarines.
There were.
You missed the submarine. You could have stopped the war.
I probably could have.
Stopped the war. It's a tragedy. And then you, but this is a sign of how teachers can influence people. They were always telling you you're not good enough. You're a 75 student. You couldn't even ask out the girl because you had been grouped as a C and she was an A.
Right. Yeah. For our prom, they divided the class into A, B, and C. I was in the C list, so I couldn't ask out somebody from the A list. I could only ask out somebody from either the C list or the B list. So I went with my cousin.
And since we're on it, you talk about sitting on the porch with your friend Harold Ramis and telling jokes, and I'd love to be a fly on the wall, but do the one about the Orthodox kid with the yarmulke who goes to the strip joint as well.
Oh, this wasn't a joke. This is true.
Well, it was a funny story.
We went to yeshiva, and of course, there's nothing more horny than yeshiva boys. We were 16, 17 years old, and we were told, maternist, you can't touch, you can't think, you can't watch, you can't do anything. And one of us, I don't remember who it was, made the greatest discovery in history that if you took the bus from Port Authority Terminal over to Union City, New Jersey, there was a strip joint. And we could go to the strip joint and watch what we couldn't touch. And so one day we all cut school and decide to get on the bus and we go to watch the strippers. And our friend Irving comes with us. Irving was more religious than we were, and he refused to take off his kippah. We, of course, took off our kippah, pretended, we were other kind of, but he wore his kippah, and of course, he sat in the front row. You get the best seats, and a guy in the back, a drunken guy in the back, is yelling, "Take it off! Take it off!" Irving thought he meant his yarmulke, so he stood up and said, "I will not. This is my religious practice." To this day, he's a lawyer in Washington. Every time I see him, I say, "Irving, take it off."
All right, this is scandalous. We have to talk about serious constitutional issues here at the National Constitution
Hey, we're talking
Center.
about religious liberty and strip
Right.
joints. That's pretty
You probably
serious,
had a case
right?
like that later on. Yale Law School, you have very kind words for Alexander Bickle. Who were the great influences on your constitutional thinking?
Alex Bickle was one of the great constitutional scholars. Of course, he's on this long list. I want to create a long list of faculty members that Harvard didn't hire. It would be the greatest faculty in the history of the world. Richard Posner, Alex Bickle, Bruce Ackerman. I mean, we've had such bad judgment in who we've hired. Present company may be included. I don't know. But Alex Bickle was a genius and helped kind of reformulate a new way of looking at the Constitution. John Ely, who was my classmate, was a big influence on me. Telford Taylor was probably the major influence in my career choice. General Telford Taylor was a young man in the intelligence agencies of Europe at the end of the Second World War out of Harvard Law School. And Robert Jackson is appointed to become the chief prosecutor at Nuremberg. And he hears about Telford Taylor, and he says, "Get that kid. I want him to be my deputy." So next day, Lieutenant Telford Taylor is now General Telford Taylor, the swiftest promotion in the history of the Army, and he becomes the chief prosecutor at Nuremberg, and was my teacher at Yale, and was also a constitutional litigator in the Supreme Court, and I wanted to be him. I just wanted to be like him. I could never choose, so I wanted to be a teacher, I wanted to be a litigator, I wanted to be a writer. I always wanted to be everything, and Telford was everything, so he was a tremendous influence on my life.
And then you had these two great clerkships with Judge Bazelon and Justice Goldberg. What did you take out of them?
Well, a lot of things. My father worked 6 days a week. He was not well educated. He didn't graduate high school, didn't read. My house was not a typical, what you stereotypical Jewish house. I had no books in the house. I had no art, no music, and I love music, art. I'm going right from here to the Barnes Museum. We go to the opera all the time. Don't know where all that comes from, because it didn't come from my house. So my father was never home. He worked 6 days a week. He had a little store on the Lower East Side. I did not have a close relationship with my father. I think in a lot of Jewish homes, the mother was really the person who dominated, and the father was out there working very, very hard. He worked on Sundays. And so when I met Judge David Bazelon and Justice Arthur Goldberg, both of whom were my father's age, they became real father figures to me. They were both Jewish liberals from Chicago, both serious intellectuals, both taught me how to be kind of Jewish but activist and liberal, and they were both incredibly important figures in my life. They were very different. Goldberg decided he knew exactly what I should be in life. He got me my first job without asking me. It was a great job to be one of Robert Kennedy's assistants, but I didn't want to do that. I wanted to go and teach at Harvard. So Bazelon said, don't ever fit in anybody else's footsteps, just make your own life. Goldberg knew what I wanted to be. He ultimately wanted me to be a justice of the Supreme Court like him. Now, he was lucky, because he had a clerk the year after me who did become a justice of the Supreme Court, Stephen Breyer. But it was never my way to be a judge. And I didn't want to be Arthur Goldberg. I wanted to be me. So, but I remained his law clerk till the day he died. I remained Dave Bazelon's law clerk till the day he died. These are clerkships for life. And I try to do the same thing with my research assistants. I'm in touch with 50 or 60 of my research assistants all the time. I maintain a very close connection with them. They've gone on to great things. John Sexton, the president of NYU, Joel Klein, who was the chancellor of the New York City school system, Jamie Gorelick. I mean, just a series of phenomenal, Elliot Spitzer. Let me tell you, it wasn't Elliot's fault. It was all my fault. He used to work so hard for me. He would be in my office at 8 in the morning. He'd be there until 10 o'clock. I remember one day saying, Elliot, do something fun. Have some fun. Who knew that 20 years later?
All your fault. Speaking of which, I want to talk about one of your first important cases involving obscenity. And that was I Am Curious Yellow. And it was this, I guess, softcore movie. And the Supreme Court in the 60s is grappling with obscenity standards. And there's this incredible oral argument where, well, I'll let you tell the story. You get two judges with very different approaches.
Right. Well, I'm 30 years old, and I'm asked to argue my first case in the United States Supreme Court on behalf of the movie I Am Curious Yellow, which today you could show on general television, but in those days regarded as the most salacious movie in history. And they sentenced my client to jail for a year for showing the movie. This was the Symphony Cinema Theater right across the street from Symphony Hall in Boston. The week before it showed the movie Closely Watched Trains about the Czechoslovakian woman in the Holocaust. This was an art movie theater, and a poor guy named Karalexis, a Greek-American immigrant, gets sentenced to a year in jail for showing the film I Am Curious Yellow. So I get to argue the case. We win it in the court below, and we have to argue in front of the newly appointed Chief Justice Warren Burger, who was an imbecile. I mean, he had an IQ. He was beautiful. He had the most gorgeous white hair. He was handsome, but he just couldn't hold an idea in his head for more than, just was not at all bright. So I get up to argue the case, and you have some very smart justices there. He dominates the argument. He says, well, what if it was a bear baiting contest? Now, coming from Brooklyn, I didn't know what a bear baiting contest was, but I assume something in which the bear gets hurt. And I said, well, Your Honor, of course, the Constitution permits the states to have laws protecting animals from cruelty. He said, all right, if that's your answer, well, what if it was a film of a bear baiting contest? So I said, well, obviously, if you could prevent the bear baiting, you could. Well, what if there were 5 bears? But he had assumed that each of the questions I would answer no. His law clerks had written out a series of questions based on a no answer to the previous questions, but I had answered yes. And so his questions were moronically irrelevant. And the other justices were sitting there looking at this Chief Justice, and he was just embarrassing them. And he dominated the entire argument. And of course, the court decided the case on procedural grounds, never mentioned bears, never mentioned anything. But it was my first experience arguing in the Supreme Court. It was the dumbest argument I ever participated in my life. I had more intelligent arguments with the butcher in Borough Park in Brooklyn than I had with the Chief Justice of the United States. Since that time, obviously, the current Chief Justice is probably the best lawyer ever to serve on the United States Supreme Court in terms of his legal qualifications, his legal experience. He's just an absolutely brilliant constitutional litigator. I agree with him about nothing. But 2 things. One, he's the nicest man in the world, just a sweet, nice guy. And second, in terms of just lawyerly skills and lawyerly ability, he's just unparalleled in his ability, I think.
And here's a great picture of you with him in front of his fireplace, and he was your former student. What was he like as a student?
Well, I didn't have him in my class. He was just a student at Harvard Law School. He knew me. I knew him slightly, but not well. The guy who's really mad at me is one guy who twice applied to my course on legal ethics. We have a mandatory course on legal ethics, and only 50 students could be in it because we want discussion. So every year I have 400 or 500 applicants to my 50 class legal ethics, and twice I turned this guy down. I didn't do it, it was the computer. And every time I try to go to the White House, the guy says to me, look, why should I invite you to my house? You didn't invite me into your class. So I had the bad luck to exclude President Obama twice from my class. I don't know whether Roberts ever applied to my legal ethics class, and I don't recall him as a student. I just recall him knowing him as a person. And Elena Kagan was my student. She sat right next to Jeffrey Toobin, and they had their hands up all the time. And Ted Cruz was my student. He walked into the class with his right hand up high and kept it up the entire semester. So he was a very good student.
Conservatives liked your class, and you respected them, and you gave them as good as you took.
I loved having conservatives in my class because I hate preaching to the choir. Number one, I don't like to preach in class at all, but I like having different points of view. And the first, I would say, 10 years I taught at Harvard, there were no conservative viewpoints expressed in class. There were no radical left viewpoints either. They were all kind of, liberal, Democrat, kind of fuzzy-wuzzy points. But ultimately, the Federalist Society gets formed. The Constitution Society gets formed. There's much more of a clash between right and left. Feminists come. African-American students come to the class. Muslim-American students come to the class. The classes become much more diverse and much more interesting.
Speech has been a theme of your career, and you surprised many people by defending narrow speech codes. But then when you tried to write one, no one could agree. Tell us about that.
So my life has been devoted to promoting free speech. I got into such serious trouble with my mother when I defended the rights of Nazis to march in Skokie.
What did she say, by the way?
She said, "Which side are you on, the Jews or the Nazis?" For her, it was very simple. I said, "Ma, it's free speech. It's free speech, free speech. Nazis or Jews? Who are you going to pick?" So I said, "Look, I'm not on the side of the Nazis. I just don't think we should have censorship. If people want to walk through a neighborhood with signs, they should be allowed to do that." So I've always been in favor of free speech. But I am in favor of narrow speech codes on universities. Why? Because we already have speech codes. Can you imagine a professor at a law school or at a college pointing to a black student and saying, "Hey," and then using the N-word? Or calling on a woman student and saying, "Oh, by the way, chick," or "dame," or something like that? You know, of course they'd be fired. You can't do that in a school. You can't demean students based on their race, their ethnicity, their sexual orientation. So we already have a speech common law. And I don't want the deans making these decisions or some administrative board. I want to know in advance what you can say and what you can't say. I want to know, for example, whether I can use the N-word in a classroom in using an example about words that are prohibited or not. One of my colleagues, Randy Kennedy, who's African-American, wrote a book whose title is Nigger. That's the title of the book. And it's a word I never, ever use in my life, never used it in all of my life. But when you're reading somebody's book title, it's an appropriate word. Or when once when I was teaching early in my career, I was talking about plea bargaining, and a student, a very nice student I became friendly with later, raised his hand and said, "Well, if I had been the defense attorney, I would have tried to Jew him down a little bit more." And then everybody in the class looked at him, and I looked at him. He had no idea he was saying anything offensive. And of course, how many of us have used the word gypped in our lives, welched, Indian giver? You know, all of these terms are ethnic slurs. It's interesting that the word niggardly has nothing to do with the N-word, but the word denigrate does. To denigrate is to reduce to the status of Negro. And, you know, that's a word that probably we ought to be more sensitive about using. But, you know, I want to know what I can say and what I can't say. I want to know whether I can joke about things, not joke about things. You know, whatever the school tells me, I'll live by their code. But I don't want to learn after the fact or have a student learn after the fact that these are things that are prohibited. So I do favor narrow speech codes. We couldn't draft it at Harvard because nobody could agree.
Not the first time, I'm sure.
Right.
So I guess earlier this month was the 50th anniversary of New York Times versus Sullivan. Not a surprise, because it was decided when you were a law clerk. And you helped Justice Goldberg write his concurrence. We had a great debate, a podcast debate last week between Richard Epstein and Jeff Stone about whether New York Times versus Sullivan was a good thing. And Epstein said it was just a terrible thing for free expression.
Why am I not surprised?
Yeah.
Look, when we got assigned to do the concurring opinion in New York Times versus Sullivan, first the story.
Yeah, of course.
There's always a story. So one day, I come out to Justice Goldberg's chambers, and there is a basket of fruit. And I hadn't had breakfast that morning, so I took a banana. It was for Justice Goldberg. It was his birthday. And I took a banana, and I ate the banana. And Goldberg comes back from court that day, and he says, "What's that?" I said, "Oh, it's a basket of fruit for you. Happy birthday, Mr. Justice." "Who's it from?" "Katharine Graham, the publisher of the Washington Post." He said, "We have New York Times versus Sullivan in front of us. You have to return that basket." I said, "But Mr. Justice, I ate a banana." He said, "You go down to the fruit store, you buy a banana, you put it back in that basket, and then you return it." He did not want to be influenced by a banana or have me influenced by a banana. So when the case first came in, Goldberg was very skeptical. He loved free speech, but he had been attacked a lot in his career as Secretary of Labor. And some of the attacks had been pretty bitter, and some of them had been ethnic, with a name like Goldberg. And finally, we sat around with the two clerks, and my co-clerk, Lee McTurnan, played a very, very important role in this particular decision. And Goldberg said, "Look, I'm going to bite the bullet. I'm going to join the majority on this, but I want to write a concurring opinion saying it's going to be costly. It's going to have a real impact on whether people are going to run for office. You can attack them. You can say things about them. And I've been victimized by that over and over again. you can go online and you can see that I murdered my first wife. It's on a Holocaust denial website from Melbourne, Australia. I can't find the guy. My first wife died tragically, but I did not murder her. You can also find on the website a cartoon of me done by another Holocaust denier, in which I am sitting in front of a television set watching the Israelis murder Palestinian children in Lebanon, and I am masturbating in joy to watching these scenes. And you can get those online. They're disgusting, they're despicable, and worse. Anybody who's a public figure can be maligned and attacked in the worst possible way without any recourse. My children read this stuff, my grandchildren read this stuff. It's horrible. That's the price of New York Times versus Sullivan, and it's a price worth paying. Because if you think of what the opposite would be, everybody in politics is pretty thin-skinned, and if you started having lawsuits against everybody who was in any way controversial, it would really weaken the Constitution considerably. So it's a cost worth paying, and if you don't like the heat, stay out of the kitchen. I mean, if you want to be in public life, there's still a lot of protection for people who stay out of the public life. But if you want to be in public life, you have to understand, particularly today with the internet, that you're going to get blasted all over the case. My wife and I are now actively involved. We have a condo in Miami Beach. There's a law in Massachusetts. If you're Jewish and you turn 75, you have to spend at least 3 months in a condo in Miami Beach. So we don't break the law. We bought a condo in Miami Beach. And it was designed by a beautiful architect named Michael Graves, wonderful, wonderful architect. And some of the people in the building think it's not glitzy enough, so they want to make it glitzier. So my wife is kind of involved in the campaign to preserve Michael Graves' aesthetic image of our building. And you should read the blogs that are coming out about us. They're just terrible. And, you know, Carolyn is now a qualified public figure because she thrust herself into this campaign,
vortex, yes.
And she now can be criticized, and the people who are calling her names have qualified immunity as the result of New York Times versus Sullivan. Welcome to the real world of the current internet.
And yet in Europe, it's the opposite, and you were sued in Italy because you
Criminally indicted.
Criminally indicted
Oh,
because you
it's criminally
criticized a
indicted.
judge and it was read in Turin or something like
What happened is in my office one day, and I get a letter saying you're under indictment in Italy for having criminally defamed a judge on this and this date and this year. Check my calendar that date. I did two things. I taught 150 students at Harvard Law School, and I had lunch with a federal district court judge. Pretty good alibi. I was not in Turin that day. But I did have a phone call that day from an Italian editor in New York for a newspaper called La Stampa, asking me if I would comment on a decision by an Italian magistrate judge who freed terrorists, two terrorists, on the ground that they were freedom fighters. And I asked them to send me the opinion in English. They did, and I read the opinion carefully, and I commented on it. And I said it's a Magna Carta for terrorism, and it reflects ignorance of international law. She sued. She filed a criminal complaint against me, the judge, for criminal defamation, and the prosecutor upheld it. So for 7 years, I've been under indictment in Turin, Italy. Every time we go to Italy, I hold a press conference. I say, here I am, arrest me, I'm ready to stand trial. You know, obviously, it's not going to happen, but technically, under Italian law, I've committed a crime.
My love-hate relationship with the Scalias. That's a great vignette. Tell us about it.
So when I was in Brooklyn College, I ran and became president of the student body, and one of the things I ran on was as a liberal, because any of you by any chance go to Brooklyn College? Yeah, hey, how about that? So you'll remember Brooklyn College in those days was called the Little Red Schoolhouse, and they had President Harry Gideons, who was brought in from the Midwest to get rid of the communist influences in all the city colleges. They were thought to be too left. And so I ran on a campaign of protecting the rights of faculty and students to express free speech, and so I got elected. And one of the professors on the other side who was trying to get rid of another professor was a man named Eugene Scalia, who was Justice Scalia's father. Eugene Scalia was chairman of the Romance Language Department. One of the people in his department was a guy named Harry Slockower, who refused to take a loyalty oath because and refused to name people who had been in some lefty organization in the 1930s. And I supported Slockower and got to meet this wonderful man, Eugene Scalia, who was the most charming, nicest, right-wing guy. So when Justice Scalia was a student at Harvard Law School and then subsequently a professor at Chicago, I got to know him a little bit, and we knew each other mostly through talking about his father. And just the other day, I wrote a book against him. I wrote a book called Supreme Injustice, where I really take him on for Bush versus Gore. And we know we disagree about just about everything, but we share a love for opera, an admiration for his father. We have a common background. He went to parochial school in New York at about the same time I did. He went to Catholic parochial school. I went to Jewish parochial school. We have very similar upbringings in different religions. I have a lot of respect and admiration for his views and his ability to articulate them, though I fundamentally disagree. So we've had this love-hate relationship over the years, and it's not surprising that you can do that. His best friend on the Supreme Court is Ruth Bader Ginsburg, and they disagree about virtually everything.
Now, there's one experience in this book that we actually shared. This was the time we were both asked to testify about the history of lying during the Clinton impeachment. And I gave a very, I'd written a piece in the New Yorker about the history of lying and gave a sort of scholarly presentation. And then you had this incredible exchange with Congressman Barr, who said you weren't a real American. And I have to say at this point, I've never forgiven you for this. You gestured very theatrically in denouncing Congressman Barr, and the next day in the Washington Post, we're on the front of the Washington Post, your hand is completely covering my face. So the only chance I had to be on the front page of the Washington Post, Alan Dershowitz is literally blocking me because of your theatrical
I've been
gesture.
upstaging people for years.
I want an apology, sir.
You have an apology.
But tell us, that was a great exchange.
Our daughter is a professional actor off-Broadway, and so we'll have to tell her about the upstaging and not to do that to friends.
I forgive you.
Okay. So I start testifying, and my whole testimony was the hypocrisy of Congress in not caring about serious perjury. And police perjury is rampant in the United States today. Policemen are constantly being told, essentially, to lie about the circumstances underlying illegal searches and seizures. I don't believe the police deliberately lie to frame innocent people. That's not America. It may be Iran, it may be China. It's not America. But I think when the policemen engage in a search that's illegal and find drugs or find a gun, they are essentially taught to lie about those circumstances, to say they saw a bulge, they saw something suspicious, and Congress never does anything about that. So I pointed out the hypocrisy. And then Congressman Barr, who since he's left Congress has turned out to be quite a civil libertarian,
great civil libertarian.
In many ways, turned to me and said, well, I don't know about you, but real Americans. And I said, whoa, don't ever call me anything but a real American. When my grandmother came over, and I lectured him about how bad that term real American is. And he said basically, I didn't mean anything, just Midwest. Well, there's no such thing. People who speak with accents are real Americans. My grandmother, who came from Poland, never lost her accent. July 4th, she would make us go to the Statue of Liberty and sing not only the entire national anthem, but the second verse that nobody knows. My grandmother knew the second verse of the national anthem. I don't remember it. I don't remember it. If my grandmother were here, she could sing it.
No one remembers it.
And so, I grew up in a family of tremendous patriotism, tremendous love for America. This is the country that rescued our family from the Holocaust and from the persecutions of Europe. Nobody could be more American than our family. And to have somebody suggest that I was anything other than a real American. Now, he may have thought I was an academic, therefore not a real American. That's a possible interpretation. But I think it was a combination of those factors. And then Judge Higginbotham, who came right after me, did the same thing. And said, how dare you suggest that we're anything but real Americans. We're patriotic, we love America, and we want to see it maintain consistency in how it deals with lying.
It was an incredible day. Congressman Hyde asked you if you'd been to Auschwitz. It was really something. You say in the book that Robert Bennett, President Clinton's lawyer, committed a serious blunder by allowing his client to fall into a perjury trap. Tell us about what
I was still amazed to me. John Kennedy, just before he was killed, was the editor of George magazine, and he asked me to do an article for what turned out to have been, I think, the last issue of George magazine, on the 10 greatest legal blunders of the 20th century. And number one and number two were Bennett. The idea that a lawyer would allow Bill Clinton to testify about his sex life in a deposition. Depositions are the most open-ended kind of inquiries. You cannot object on the ground of relevance. At the time, he knew that there were these kind of allegations floating around. And so the only three alternatives were for the president to admit things that would be very dangerous for him to admit publicly, to deny them, which would be perjurious, or to refuse to answer, which would be contempt. And Bennett never told the president about the fourth option. The fourth option, since the lawsuit was for a specific amount of money, $750,000, was simply to walk over to the clerk of court with a certified check for $750,000, deposit it with the clerk of court, and the case is over. It's called a default. It's done every day of the week. If you have a lawsuit against you, even if it's a frivolous lawsuit, one of your former employees sues you for $10,000 for false dismissal, and you know he knows secrets about your company that you don't want revealed, you pay him the $10,000. And Bennett never told the president that he had that option. And how do I know that? Because President Clinton told me that. And then I checked it with Bennett, and Bennett acknowledged it. He said, he thought it would be a stupid idea. I wouldn't want to tell the president about that. It would be a bad idea. Let the president make that decision. And if he hadn't testified at that deposition, he wouldn't have been impeached. And it was awful for him, awful for America. And it was one of the worst legal judgments I've ever seen. I still to this day don't understand it. I think one of the reasons is when you're representing a celebrity, you don't often want to tell them things they don't want to hear. You confuse your role as lawyer and cheerleader. And I tell my students, if you ever represent important people, celebrities, you have to be prepared to walk into every meeting being ready to be fired. You have to tell them what they don't want to hear. I'll tell you an interesting story about that. I had a very close friend, and was also my cardiologist, named Bernard Lown, who was one of the great cardiologists in Boston. And he was so famous that he had a lot of very famous people, including King Hussein was one of his patients. And I can tell the story because it's in Bernie's book. And so Bernie gets flown over by King Hussein's private jet to Amman to examine the king, who's having some chest pains or something like that. And he comes into the room, and there's the king wearing his robes. And there are about 25 retainers standing around, including about 10 doctors and 5 nurses. And Bernie says, I only examine patients alone, just with me and him in the room. Oh, no, the king is not allowed to be alone with you. And by the way, he has to take off his robe. I have to examine him naked. Oh, no, the king can't be naked in your presence. And Bernie said, well, then I have to leave. Just take me to the plane. I can't perform my medical services without doing it the way I think. Finally, the king said, okay, and he examined him and said, hey, king, you put on a few pounds here and there. You're doing this, you're doing that. He had to tell the king what the king didn't want to hear. He had to be able to be direct with the king. He had to be able to insult the king in many ways. When you're representing the president, you have to be willing to put your finger in his face and say, Mr. President, you can't testify about your sex life. Nobody will believe you. You can't testify about who you've had sex with. I wouldn't believe you. Nobody is going to believe you. You have to figure out a way of not testifying. You have to be able to say that to the president or the CEO or Michael Jackson or whoever it is you're representing or providing medical care to. If you're the doctor and Michael Jackson says, I want this drug to put me to sleep, you have to say, no, you're not getting that drug. That's against medical advice. You can't give people what they want if you're going to be a professional.
What's the toughest advice you've ever given a client?
The toughest advice is always plead guilty. But I'm innocent. Doesn't matter whether you're innocent or guilty. There's a 60-40% chance you're going to get convicted. And if you get convicted, you get in 10 years. I got you a deal where you get in 6 months. But I'm innocent. But you can't take that chance. But how can I get up and say, I did it, I'm innocent? Because that's the way the system works, unfortunately. It's a terrible system. but you get 10 times often the amount of punishment for pleading not guilty and going to trial. We claim we don't have a penalty attached for invoking your constitutional right to trial by jury, but we do. And that's the reality. And telling an innocent client that he has to plead guilty is the hardest thing you have to do. And you have to persuade him to do it. The other thing is to persuade your client not to take the witness stand. But I'm innocent, and I've persuaded everybody, and I'm very articulate, and I'm very able to. That's not the way it works. If you testify, everybody's going to forget about all the evidence that we put in previously. They're just going to look you in the eye and see whether they like you. So it's very hard being a criminal defense lawyer, and you often have to tell clients what they don't want to hear, what you don't want to tell them, but you have to do it.
All right, so many great questions from our wonderful audience, and the first one is, can or should a defense lawyer defend a defendant he knows is guilty?
Yes, and if you don't believe me, listen to Abraham in the book of Genesis. Abraham meets God in chapter 18. By chapter 19 already he's saying to God, anybody understand Hebrew? Khalilah, Khalilah, far be it from you, God. You will sweep away the innocent with the guilty. What if there are 50 innocent people in the city of Saddam? And there weren't 50 innocent people. And Abraham argued forcefully for the guilty people of Saddam. Moses, when he came down from Sinai and he sees the Hebrews dancing around the golden calf, he defends them. He says to God, if you don't forgive them, you can erase me from your book. I mean, there's a long tradition of defending the guilty, and the important thing is think of the alternative. The alternative is if you wouldn't represent somebody you think is guilty, first of all, you're not the judge and the jury, and I've had many experiences where I've thought defendants are guilty and they turn out to be innocent. The opposite, too, where I thought they're innocent and they turn out to be guilty. We're not judge, jury, and executioner. We don't want to live in a system where only people the government regards as innocent get to be represented. First of all, the government wouldn't be prosecuting them if they were innocent. Look, let's face the reality. Most defendants who are charged with crime are guilty. Thank God for that. We wouldn't want to live in a country where most people charged with crime are innocent. That might be China, Iran. It's not the United States of America. So the job of the criminal defense attorney is to defend the guilty, but to do it by ethical and lawful means. You do not put a guilty defendant on the witness stand. You do not allow a guilty client to testify. Mostly you don't allow an innocent client to testify either. So that doesn't really indicate whether you think he's guilty or innocent. But you don't do anything unethical or improper. And you don't lie to the jury. You don't lie to the judge. But you make all the arguments you can that are ethical and proper. When I did the O.J. Simpson case, everybody loved the fact that I was defending O.J. Simpson. Wow, that guilty guy gets good lawyers. He's going to get convicted, due process. Nobody hated me when I defended O.J. Simpson until he won. When he got acquitted, people were appalled. How could you do that? We were counting on you to help him be found guilty. We wanted you to be there to show the system works. You're a traitor. You actually got him to be found not guilty. And that's when people really hated it. My mother called it the oy vey OJ part of my life.
Well, in the book, you talk about the fact that you took the case because he was charged with a death penalty, and then he ended up not being charged.
Right.
And it was a coincidence that you were in the courtroom when he put on the glove.
Unbelievable. I happened to be, I was not in the courtroom most of the time. I was the God forbid lawyer. I was the guy who was going to do the appeal if and when he lost, because we all thought he would lose. I happened to be flying to Australia to give a speech. Can't fly to Australia straight from Boston. Stopped in L.A. My son picked me up at the airport. I said, Elon, let's stop off at the courthouse. I'm not doing anything today, but, busman's holiday. Let's go to the courthouse. So we turned the radio on as we left the airport. It was the most boring day of testimony. There was this glove manufacturer who was testifying about the glove. Well, when we make gloves, we do this kind of a stitch and that kind of a stitch. It went on and on and on. We were practically falling asleep in the car. I said, come on, we'll just go. We'll go in the courtroom. We go to the courtroom. I'm sitting here. OJ's sitting literally right next to me. And Darden, the prosecutor, says, Mr. Simpson, will you get up? I want you to try on the glove. Shock in the courtroom. Shocked by all of the lawyers, because we knew that under California law, you could ask a defendant to try on the glove outside the presence of the jury first to see if it fits before you ask him to do it in front of the jury. Darden didn't do that. He was so self-confident and arrogant. He just had him do it in front of the jury. O.J. puts on the glove, and of course anybody can make a glove not fit. You just make sure you stiffen your hands. Moreover, the glove had shrunk. Obviously, it had been in a refrigerator. And to do that demonstration, O.J. puts it on. And he says, goes right in front of the jury and says, it's too small. At that point, he had already testified. He didn't have to testify. It was one of the worst blunders. That one was number 3, I think, in my list of great blunders of the 20th century. You know, lawyers get clients in trouble. Martha Stewart went to jail not because of what she did, but because of who she picked to be her lawyers. She picked a bunch of lawyers who allowed her to tell her story in front of the SEC or in front of the U.S. Attorney's Office, and she got indicted for falsely telling her story. She didn't get indicted for insider trading. You know, when you get indicted after you have a lawyer, on the basis of your lawyer's advice or impeached, you know there's something wrong with your lawyer. And there are too many lawyers who get too many clients and too much trouble.
Which of the many celebrated cases did you become most emotionally involved with, and why?
I think maybe Sharansky was the most emotionally involved, because there, but for the grace of God, go I. This was Anatoly Sharansky, a great dissident in the Soviet Union. His family came from the same part of Poland, Ukraine, my family came from. His family made a right turn and went to Moscow. My family made a left turn and came to New York. Had our families switched, I'd have been the dissident in Moscow. He'd have been the lawyer in America. I'd never met him when I represented him, but I had a tremendous emotional attachment to his case and his cause. And when we helped get him out, finally, Irwin Cutler and I were his lawyers. And when he came out and he threw his arms around me, and he whispered in my ear, Baruch Matir Asurim, blessed are those who help free the imprisoned from a blessing. It was the biggest fee I ever got. Obviously, he didn't have any money. I did the case for free. But the gratification and that result, I still, when I think about it, I still get emotional.
Maybe it's a different version of the same question, but which case are you proudest of?
Well, I'm proud of that, but he really is the guy who should, I mean, he's the hero of that case. Look, I'm proudest of the cases where everybody told me I couldn't win. When I got the Von Bülow case, there were articles all over saying, oh, why is he even bothering to appeal? It's a slam dunk, it's open and shut. He'll never win. Then when we won the appeal, they said, oh, but he'll be convicted on a second trial. And, you know, he was acquitted. And I'm convinced there was no crime committed there. And I think that case also, because my son, I worked with my son on that case, he's a movie maker, and he made the film Reversal of Fortune. And I think it brought the concept of an appeal to a broader general public and made it clear that you don't win appeals just for technical reasons, that an appellate process can help really vindicate the system and also vindicate potentially innocent defendants. So I'm very proud of that case.
And are there any cases you regret?
Yeah, oh sure. Leona Helmsley. I've never met a more difficult person in my life. I mean, she was just unbelievable. She was just so mean and cruel. I can't tell you, I can only tell you things that are matters of public record, but there are so many of them. One day, we were sitting and having tea together in one of her hotels, breakfast. I was giving her legal advice, and my tea came, and it had a little bit of liquid in the saucer. I didn't even notice it. She saw it. She took the tea cup and the saucer, threw it on the marble floor, and then said to the young Latino waiter, now get on your hands and knees and beg me for your job back. And at that point I said to Leona, I will never be seen in public with you again except in court. I don't want to be associated with your horrible conduct, and you want me to be your lawyer? That's fine. I'll represent you in court, but don't ever, ever ask me to be with you again in another public place. And I never saw her again in public. I never saw her again outside the courtroom. And that was just typical of her behavior. She was just difficult, impossible. She had a very important case, and the reason she was convicted is because she was the queen of mean. They indicted her on April 15th, tax day, for what was a relatively minor tax violation. But it made me think hard, why would a woman who had in the bank, the day she was indicted, she could write a check for $3 billion, $3 billion. Why would she cheat for $10,000? I mean, basically what they accused her of doing, she'd go into jewelry shops on Fifth Avenue, Winston or Cartier, and she would buy a bracelet or something or earrings, and she had to have them immediately, but she didn't want to pay the tax, the sales tax. So this is the accusation, so she would wear the earrings out, but have them send an empty box to her home in Florida so that she didn't have to pay the, 6% in those days, 7% sales tax. So why would a billionaire risk a year of her life? She had a relatively short life left. Why would she risk what she had a small amount of to get more of what she had unlimited amounts of? I would say the same thing about Mike Tyson. Mike Tyson had sex with more than 10 women in the week before he was indicted for having sex with the 11th woman, and she accused him of rape. Why would you put at risk your life, your career, your championship to get more of what you have unlimited amount of and put at risk what you have limited amount of? It's the craziest thing, and so many of my clients have done that, and they just seem never to learn, and I just don't understand it.
One last question, unfortunately, because I'd love to go on. It's been such an honor to have you at the Constitution Center. It's been so much fun. I'm so delighted that you bought in the gift shop our extremely tasteful tie, which is very understated, actually, and I'm just very glad to see it on you. This is the question. This beautiful place, the National Constitution Center, is devoted to the idea that citizenship is a high privilege, that all citizens can participate in a conversation about what the Constitution means. That's what your entire remarkable, impressive career has been about. What does citizenship, patriotism, the Constitution, what does being an American mean to you?
Well, it's, first of all, this is an amazing center. This is just absolutely amazing. And the fact that it's bipartisan. I had lunch the other day with Jeb Bush, who is he now?
He's our chair.
Chair. And he was so proud of having given an award to Hillary Clinton because for him, bipartisanship over the Constitution is crucial, and I think for all of us. I mean, there are so few things that bring us together in a country that's so divided. But commitment to our remarkable Constitution, this document, is just so unbelievable. Whether you're a Scalian who believes in the original understanding or whether you believe in a more living Constitution, I believe in both. I believe parts of the Constitution have to be defined by their original meaning, and other parts, due process, equal protection, cruel and unusual punishment, the broad things were given us under a principle of constitutional common law, where we have not only the right but the obligation to construe and interpret them in terms of their meaning today. So I think there are living parts of the Constitution and there are not so living parts of the Constitution. But this document is just remarkable. And for me, I can't imagine any greater privilege than to have been born an American citizen or to be accepted by choice as an American citizen. And, my family came over during very, very difficult times. That's why I'm so sympathetic to people who are trying to become Americans and why I understand how some of them have to do it through means that maybe today we wouldn't find acceptable. But we are a nation of immigrants. The recency of our immigration is only a matter of degree. The difference between somebody who came over on the Mayflower and somebody who most recently tried to swim from Cuba to come here, immigrants have made this country and have built this country. And for me, the privilege of citizenship should be earned, and it has to be earned not by one's past, but by one's commitment to America, one's commitment to the Constitution. My friend Yo-Yo Ma, he says the most important part of every year for him is not playing in Carnegie Hall, but when he plays at the ceremony in Boston, when his peers, he was an immigrant from France, became a citizen, and when he plays for the new immigrants and he welcomes them to America as new immigrants, he says that's the highlight of his year. And when I have an opportunity to meet new Americans, I share the same perspective. So, congratulations to all of you who are active in this wonderful center. Congratulations to this center. The Constitution is now the oldest existing document of freedom that continues to operate in the history of the world. May it go from strength to strength. May it continue and endure forever. Thank you.
That is beautiful.
Thank you. Thank you.